Creativity is really odd. Finding people with innovative ideas that can have an impact on our lives is not easy, but when they are found, they are invaluable. Leonardo da Vinci, Enzo Ferrari, Miguel de Cervantes, Steve Jobs, Stanley, or the Beatles are just a few examples. It would be fair that genius, even in the small things, was paid with recognition and resources to keep creating. But reality is more complicated. Often, inventors and creators are ignored, underpaid, copied, belittled, or stripped of their creations, especially if their ideas succeed or can do it. As a result, these people may lose the motivation to innovate, and hence society would also be deprived of their contributions to science, art, design, in short, to progress. The way to encourage creators and entrepreneurs to take the risk, go beyond the conventional, and explore the limits of the known, producing amazing products and services that benefit us all, is intellectual property. Thanks to this, creators and inventors receive protection that allows them to exploit their works with a certain advantage. In exchange, society can use them freely after a while, either to market them, create new things, or simply enjoy them. Thus, intellectual property is the mechanism that allows us to close the circle of innovation, and it's everywhere. It's what makes the names, logos, appearance, or features of products and services that did not exist recognizable to the public, and the tool that its owners have used to make themselves known and succeed. Or in other words, they are trademarks, designs, patents, utility models, copyright, and trade secrets. Each of these constitutes an intellectual property right, which grants protection to a specific aspect. Let's look at the main features. These are rights that protect the innovative aspects of products and services. Like all rights, they are subject to the applicable national or international regulations, so you need to understand them well to know how to protect your creations correctly. What about the ideas? Are not they protected? Well, no. The mere ideas? No. IP rights only protect the sensitive expressions of these ideas, either by sight, hearing, or touch. For example, a stick attached to a candy, a song, a phrase, a name, or a drawing. The support doesn't matter. The important thing is to express it. IP rights are not an end in themselves, but a tool. So you have to know how to use them. Tool, okay, but what kind of tool? A legal and business one, as it grants exclusivity, which prevents others from using or creating similar things, and can be exploited granting licenses. This means that it is not enough to be the first to create it. On the contrary, in order to obtain the exclusivity, it must also be registered, and you'd better do it quickly, since the first to do so takes the prize home. This is known as the first to file principle. Normally, you have to register in each country where you want to market, because there is no worldwide protection. But in Europe, we can also register before the EU IPO, for instance, which provides protection to trademarks and designs in 27 countries of the European Union. Exclusivity, like the superstar of Super Mario, doesn't last forever, so you have to hurry and squeeze it. Each intellectual property right has a different duration, after which it becomes public domain and anyone can use it without paying a cent to its creator. Single intellectual property right does not protect all of our product. Several are needed because each right serves to protect one aspect. Plus, they can be combined. For example, to commercialize sneakers, we can protect the intelligent transpiration system with a patent. Appearance, with an industrial design, the logo and the name of the product as a trademark, and the photos and videos of the advertising campaign by copyright. This also means that all products and services can be protected by IP rights even if you have not realized it. If you have an iPhone, you already have in your pocket almost 300 trademarks, more than 1,000 patents, few designs, and who knows how many copyrights. The industry is not relevant. The size of the company doesn't matter either. Everyone produces and deals with intellectual property rights, whether they know it or not. To ensure you know it too, we will see what each right is for so you can identify and use them with ease, recognize and reward the effort made by its creators, and punish those who try to take advantage of them. Hence Mortgage GBC AB, Alphabet Inc., ByteDance Ltd, Zinalsea, Carnicas Roche, Adeo Services, or Unilever may not sound too much to you, but they are companies behind brands like H&M, Google, TikTok, Burger King, Mercadona, Leroy Merlin, Rexona, or Ben & Jerry's. All of them were registered. That's why no one can use a confusingly similar or identical name or logo without their permission. That's why they have managed to differentiate themselves from their competitors, instilling confidence in consumers who know who these products come from and who to address if something goes wrong or if they want more. Because that is what a trademark protects. The distinctive sign, be it the name, the logo, or even the form that serves to identify the business origin of the products and services. Today, they are very popular and anyone can intuitively relate them to the types of products that they apply to. But that was not always the case. When those companies applied for registration, those brand names were totally distinctive and there were no identical or confusingly similar trademarks already registered. Thanks to this, today, these companies enjoy protection that lasts for 10 years, renewable indefinitely for identical periods, as long as they pay the maintaining fees and nobody proves that they were not as original as we were led to believe. The light bulb, the roll of toilet paper, the mouse, or the airbag are inventions that are part of our daily life, but they are also the result of long and expensive research, and patents protect exactly that, solutions to a technical problem. Getting a sports shoe with a customizable sole according to the needs of its user used to be available only to the sports and social elites. But what if someone were to create a 3D printing system that would allow midsoles to be manufactured based on the type of cushioning and flexibility the customer asked for? Well, that is precisely what the brand of the three stripes has done in the hands of Carbon, and the Adidas Futurecraft are the first shoes to incorporate this technology protected with up to 19 patents. The path has not been easy, because to patent you must meet 3 requirements: novelty, inventive step, and industrial applicability. What do they mean? There has not to be a technical feature that has not been known anywhere in the world before. That includes my own disclosures, so be careful not to disclose it before submitting your patent application. Neither can it be an easily deductible result by an expert in the field. If it was obvious, it doesn't count. And of course, it must be used for commercial purposes. Art and theories do not count. Tough, right? I know. But you can always go to utility models, the little brothers of patents. They are suitable for small improvements, their requirements are laxer, and it usually takes less time to be granted. In any case, given the speed of innovation, they will probably become obsolete soon, but their owners will still have a period of 10 or 20 years to exploit them exclusively. Aside from retro fashion, I would not be surprised if the appearance of sneakers was also quickly outdated. However, beyond what the critics say, their look is unique, and that is why their creators have been able to register them as an industrial design. This IP right protects the aesthetic elements, pure appearance, no technical characteristics. We are talking about that line, shape, texture, color, materials, or the combination of all of them, which provide a genuine impression different from any other known design. The curves of a car can improve the aerodynamic load and help save fuel, but they can also be shaped to look sleek or aggressive. The former will be protected by pattern and the latter by industrial design. Here, the details play a big role because with the rise of digital tools, the flow of information at an international level, and increasingly demanding and sophisticated consumers, the margin for creativity is less and less. But if you achieve it, you can have up to 25 years of exclusivity for renewable periods of 5 years. And after that time, we have all seen models very similar to the Converse All-Star marketed by Mustang, Levi's, Ralph Lauren. And yes, this is legal because this design is already in the public domain. What you cannot do is use the trademarks or designs that are still in force without authorization, because these are copies and counterfeits and constitute a crime. It is the most peculiar IP right. First, registration is not mandatory, since its protection is generated upon creation and the requirements are very simple. The creation must be a scientific, artistic, or literary work, that is, books, novels, poems, posts, tweets, treaties, drawings, choreographies, sculptures, advertisements, software, or even databases. And it must be original in the sense that it is not a copy of another work, not in the sense of the novelty of patents and industrial designs. This means that millions of contents protected by copyright are produced every day, and many of them are based on already protected works and created without the consent of the author or the awareness of the person who edits them. Of course, you can also find people who know very well what's on their hands and what it implies. Is it so hard to wait for the termination of the legal protection period, or to ask the author for authorization or a license, or use royalty-free content? The truth is, no. Think about it. And finally, we have trade secrets. They are not properly an IP right, yet they are used to protect knowledge that is acquired through experience, the so-called know-how, or what cannot be patented or is not worth patenting, because trade secrets protect the commercial information that has an added value for being secret. If discovered, it would lose its value. For this reason, to benefit from this legal tool, it is necessary to adopt minimum protection measures. McDonald's, with its Big Mac sauce, or the Coca-Cola Company have done so, because the multinational that started selling in pharmacies has been very careful that its original receipt remains its own, and it has not done so by registering it, but by using trade secrets, signing non-disclosure agreements with its employees, segmenting the production process, entrusting the receipt to 3 unique people, or keeping the original formula in a maximum security box. What if someone guesses it with reverse engineering? Game over. Of course, Coca-Cola can always claim that you are far from it. Or do they not say that Coca-Cola Zero and original taste the same? And those were the main characteristics of the most outstanding intellectual property rights. Wasn't that difficult, was it? Just in case, let's recap. Trademarks protect the distinctive signs used to protect products and services so that consumers know who made them, and they last for 10 renewable years. Patents are for inventions, technical solutions to a problem, and they last for 20 years. Designs that protect the aesthetic part of the products have a duration of 5 to 25 years and, like trademarks and patents, need to be registered. On the other hand, copyright does not require registration, although it is highly recommended. It lasts between 50 and 70 years and protects mainly artistic works. Finally, trade secrets protect the commercial information that has value for being secret, and its duration will depend on the discretion of the owner. You see that we did not lie when we said that intellectual property is everywhere. Now you know the most important aspects of it, and we hope you will be able to take better advantage of it and help us raise awareness among others.